This is the collapse they said would happen gradually. For 19 months, the discussion around Trump's legal defense has focused on strategy, on legal theories, on procedural moves that might create openings for delay or acquittal. The public has watched lawyers file motions, argue appeals, and present arguments to courts about immunity, jurisdiction, and constitutional protections. The legal strategy appeared coherent from the outside, a systematic effort to challenge prosecutions on multiple fronts using the full arsenal of available legal tools. But this morning, Thursday, February 20th, 2026, at 9:14 a.m. Eastern Time, that appearance of strategic coherence has completely disintegrated. Breaking news from federal courthouses in Washington, Florida, and New York indicates that the legal strategy that Trump's attorneys have been executing for the past year and a half is unraveling simultaneously across all cases. We are observing defense attorneys withdrawing from cases citing irreconcilable conflicts with their client and inability to receive payment for services. We are watching courts rejecting motions that were supposed to form the foundation of the defense strategy and imposing sanctions on attorneys for filing frivolous arguments. We are seeing federal prosecutors exploiting the chaos in Trump's legal team by accelerating timelines and pressing advantages that would not exist if Trump had competent, coordinated legal representation. The unraveling is not a single dramatic failure. It is a comprehensive breakdown of coordination, funding, strategy, and client control that is occurring across multiple jurisdictions at once. Federal pressure is intensifying precisely because prosecutors recognize that Trump's legal defenses are collapsing and that the window to secure convictions before political dynamics potentially shift is narrowing. The legal strategy has unraveled. The federal pressure is escalating to exploit the weakness. And Trump, 18 days before his criminal trial begins, finds himself without a coherent defense plan and without the legal team necessary to execute one, even if it existed. The most immediate and visible manifestation of the strategic collapse is the mass withdrawal of attorneys from Trump's legal team across multiple cases. According to court filings submitted on Wednesday afternoon and reported extensively by the Washington Post, CNN, and NBC News, 4 attorneys who were central to Trump's defense in the federal election interference case have filed motions to withdraw as counsel. The attorneys cite 3 grounds for withdrawal. First, irreconcilable differences with the client regarding legal strategy and trial preparation. Second, failure of the client to pay agreed-upon fees and retainers despite repeated requests. Third, ethical concerns about continuing to represent a client who insists on pursuing arguments that the attorneys believe are frivolous and that may subject the attorneys to sanctions or bar discipline. The motions to withdraw are filed under seal with redacted versions made public. But sources who have reviewed the unredacted versions told Bloomberg Law that the private submissions include details about specific instances where Trump overruled his attorney's advice, insisted on filing motions that the attorneys believed had no legal merit, and refused to cooperate with trial preparation activities, including witness preparation and evidence review. Judge Tanya Chutkan held an emergency hearing on the withdrawal motions on Thursday morning. According to reporters who attended the hearing, Chutkan expressed significant frustration with the timing of the withdrawals, given that trial begins on March 10th, just 18 days away. She questioned the attorneys about why they are seeking to withdraw at this late stage when they have been representing Trump throughout the pretrial proceedings and should have anticipated these problems earlier. The lead attorney seeking withdrawal, whose name is redacted in public documents but who has been identified in media reports as one of the senior partners at the firm representing Trump, stated that the problems have escalated dramatically in the past 2 weeks as the enforcement actions in New York and Florida have progressed and as Trump has become increasingly uncooperative and demanding. The attorney stated that Trump has been calling at all hours, making unrealistic demands, that he has refused to participate in trial preparation sessions that the attorneys have scheduled, and that he has publicly contradicted legal positions that the attorneys have taken in court filings. The attorney stated that continuing to represent Trump under these circumstances would require the attorney to violate professional responsibility rules and would expose the attorney to potential malpractice liability. Judge Chutkan's ruling on the withdrawal motions reveals the impossible position that courts face when defendants sabotage their own representation. Chutkan denied the motions to withdraw, stating that allowing the entire defense team to exit the case 18 days before trial would create an unacceptable delay and would prejudice the government's ability to proceed with a trial that has been scheduled for months. However, Chutkan also acknowledged the serious concerns raised by the attorneys and stated that she would revisit the withdrawal requests if the client-attorney relationship deteriorates further or if the attorneys can demonstrate that continued representation would require them to violate ethical obligations. The ruling effectively forces the attorneys to continue representing Trump through trial, even though the attorneys have stated on the record that they believe the client is uncooperative and potentially directing them to take positions that are professionally problematic. The situation creates a scenario where Trump will go to trial represented by lawyers who do not want to represent him and who do not believe they can mount an effective defense given the client's interference. The quality of representation will be compromised, which potentially creates appellate issues if Trump is convicted, but Chutkan has decided that the alternative of delaying trial to allow Trump to find new counsel is worse. The strategic foundation that Trump's legal team spent 18 months building has been systematically dismantled by appellate courts and by the Supreme Court in ways that leave the defense with no viable theory of the case. The original strategy was built on 3 pillars. The first pillar was absolute presidential immunity from criminal prosecution for official acts taken while in office. The theory was that if the actions Trump took to challenge the election results occurred while he was president and were connected to his official duties, he could not be prosecuted for those actions even after leaving office. The Supreme Court rejected this theory definitively in its ruling last week. The second pillar was that Trump's speech and conduct on January 6th were protected by the First Amendment because he was expressing political opinions and exercising his right to challenge election results through legal processes. The D.C. Circuit rejected this theory in its opinion, affirming the denial of immunity, finding that incitement to violence and conspiracy to obstruct official proceedings are not protected speech. The third pillar was that Trump genuinely believed the election was stolen based on advice he received from attorneys, and that therefore he lacked the criminal intent necessary for conviction on fraud and conspiracy charges. This good faith reliance defense has been severely undermined by the evidence that multiple administration officials and attorneys told Trump that his election fraud claims were false and that his pressure campaign on state officials was illegal. With all 3 strategic pillars destroyed, Trump's attorneys are left with no coherent theory of defense. According to sources familiar with internal defense strategy discussions who spoke to Politico and the New York Times, the legal team held multiple emergency meetings in the past week trying to develop alternative approaches. The options discussed include attacking the credibility of government witnesses by highlighting their political biases or their own potential legal problems, arguing that Trump's conduct does not meet the specific elements of the crimes charged, even if the conduct was inappropriate, and attempting to create reasonable doubt by emphasizing uncertainties in the evidence or contradictions in witness testimony. None of these approaches constitute a comprehensive defense strategy. They are tactical maneuvers that might create openings with individual jurors, but that do not address the fundamental strength of the government's case. The problem the defense team faces is that the documentary evidence is overwhelming. There are recorded phone calls where Trump pressures state officials to find votes. There are text messages and emails showing that Trump was informed his fraud claims were baseless. There are contemporaneous notes from White House meetings where attorneys told Trump his plans were illegal. The defense cannot contest the authenticity of this evidence. They can only try to provide alternative explanations for Trump's conduct. But those alternative explanations are severely constrained by the fact that the courts have already rejected the immunity and First Amendment defenses. The federal prosecutors in Special Counsel Jack Smith's office are intensifying pressure specifically because they recognize that Trump's legal position has collapsed and that the opportunity to secure conviction is optimal at this moment. According to sources inside the prosecution team who spoke to the Washington Post and CNN, Smith held a meeting with his senior prosecutors on February 15th to discuss trial strategy. The meeting focused on how to exploit the weaknesses in Trump's defense and how to prevent the defense from recovering through delay tactics or through finding last-minute strategic innovations. The prosecution team decided to oppose any further continuances of the trial date regardless of the circumstances, to file pretrial motions that force the defense to commit to specific positions before trial begins, and to accelerate the pace of the trial once it starts to prevent Trump from using courtroom antics or disruptions to create delays. Smith's team has identified the defense's lack of coordination and the breakdown in attorney-client relations as vulnerabilities that can be exploited through aggressive motion practice and through trial tactics that force the defense to make quick decisions without adequate preparation time. The prosecution has filed a motion in limine asking Judge Chutkan to prohibit the defense from presenting certain categories of evidence or argument at trial. Motions in limine are standard pretrial tools that help define the scope of what juries will hear, but Smith's motion is unusually comprehensive and aggressive. The motion seeks to exclude any evidence or argument related to presidential immunity, any evidence suggesting that Trump's speech was protected by the First Amendment, any evidence about alleged irregularities in the 2024 election that Trump claims justified his concerns, and any character evidence suggesting that Trump is generally truthful or law-abiding. The motion argues that these topics have already been litigated and rejected by courts, or that they are irrelevant to the charges and would only confuse the jury. If Chutkan grants the motion in full, which appears likely given her previous rulings, the defense will be prohibited from presenting its original strategic arguments to the jury. The defense will be limited to challenging whether the government has proven each element of each crime beyond a reasonable doubt based on the specific evidence presented. This is a much narrower and more difficult defense to execute successfully. The financial pressure on Trump's ability to fund his defense is creating a secondary layer of strategic collapse that compounds the legal problems. The defense team's retainer agreements, which have been filed with the court as part of the withdrawal motions, reveal that Trump agreed to pay approximately $7.2 million in fees and expenses for the trial phase of the election interference case. The agreement required Trump to deposit $3 million into the firm's trust account by February 1st, with the remaining $4.2 million to be paid in installments as trial progresses. According to the attorney's submissions, Trump made an initial payment of $800,000 in early January, but has not made any subsequent payments despite multiple requests. The firm's trust account balance allocated to Trump's case is now approximately $350,000 after accounting for expenses incurred through mid-February. At the rate the firm bills for trial preparation and courtroom time, that balance will be exhausted within 1 week of trial starting. The attorneys have informed Trump that they cannot continue representation beyond the point where the trust account is depleted unless additional funds are deposited. Trump has reportedly told the attorneys that he does not have the liquidity to make additional payments because his assets are frozen by the receivership and by federal forfeiture actions. The funding crisis creates an impossible situation for the defense team. If they withdraw from the case due to non-payment, they potentially violate their professional obligations to the client and to the court given the proximity to trial. If they continue representing Trump without adequate funding, they cannot pay for expert witnesses, investigators, and support staff that are necessary for mounting an effective defense in a complex federal case. The firm is effectively being asked to finance Trump's defense using its own resources with no guarantee of repayment. According to sources inside the firm, the partnership held an emergency meeting on Tuesday to discuss whether to continue representation under these circumstances. The partnership was divided, with some partners arguing that the firm has an obligation to finish what it started and that withdrawing would create reputational damage for the firm. Other partners argued that continuing to work without payment sets a dangerous precedent and exposes the firm to significant financial losses. The compromise that emerged was to seek court permission to withdraw, but to continue representation if the court denies the motion while simultaneously reducing the level of effort devoted to trial preparation to match the available funding. This compromise guarantees that the quality of Trump's defense will be inadequate because the firm is not investing the resources necessary to prepare thoroughly for trial. The coordination failures between Trump's legal teams handling different cases reveal that there is no central strategy coordinating the various defenses and that decisions made in one case are creating problems in other cases. Trump faces criminal charges in Washington for election interference, potential charges in Georgia for similar conduct that is still under investigation, despite previous indications that charges were imminent, civil enforcement actions in New York, and federal forfeiture proceedings in Florida. Each case is being handled by different attorneys who operate independently and who apparently do not coordinate their strategies or their public statements. The lack of coordination has resulted in Trump's attorneys making contradictory arguments in different forums. In the criminal case in Washington, the attorneys argue that Trump genuinely believed the election was stolen and that he was acting in good faith to protect election integrity. In the civil case in New York, Trump's attorneys argued that the financial statement valuations were based on reasonable estimates and professional appraisals. But the evidence in the New York case shows that Trump inflated values deliberately and systematically, which contradicts the good faith defense in the criminal case. Prosecutors in the criminal case are planning to introduce evidence from the New York civil case to undermine Trump's credibility and to show a pattern of deliberate dishonesty that is inconsistent with the good faith defense. The lack of coordination extends to public statements where Trump himself frequently contradicts the legal positions his attorneys are taking in court. Trump continues to post on social media claiming that the 2024 election was stolen and that he was justified in taking extraordinary measures to prevent what he characterizes as a constitutional crisis. These statements undermine the defense strategy in the criminal case, which is trying to argue that Trump was relying on legal advice and following processes that he believed were legitimate. Trump's public statements suggest that he views his conduct as justified regardless of what his attorneys told him, which supports the prosecution's theory that Trump acted with criminal intent and knowingly violated the law. The defense attorneys have reportedly asked Trump repeatedly to stop posting about the case on social media, but Trump has refused. The attorneys are in the impossible position of trying to defend a client in court while the client is simultaneously making public statements that destroy the defense. The federal pressure is intensifying not only through the criminal prosecution, but through coordinated regulatory and civil enforcement actions that are designed to deplete Trump's resources and to eliminate his ability to mount effective defenses across multiple fronts. The IRS enforcement of tax liens, the New York receivership liquidation of assets, and the federal forfeiture proceedings are all proceeding on timelines that converge in mid-March, the exact period when the criminal trial will be consuming Trump's attention and resources. According to analysis by legal experts who spoke to The Atlantic and The New Yorker, the timing appears to be coordinated to create maximum pressure. Whether the coordination is explicit, meaning that prosecutors and regulatory agencies are actually communicating about timing, or whether it is emergent, meaning that independent actors are all moving at the same time because they recognize the same vulnerabilities, the effect is identical. Trump faces simultaneous crises that exceed his capacity to manage them all effectively. He must prepare for a criminal trial that could result in imprisonment while simultaneously dealing with asset liquidations that are destroying his business empire, and while managing the political fallout from collapsing support among Republican officials and donors. The intensification of federal pressure reflects a strategic calculation that the window for securing accountability is narrowing and that aggressive action is necessary before political circumstances potentially change. The midterm elections in November could shift control of Congress. If Republicans retain the House or gain seats in the Senate, despite current polling predictions, pressure could build on the Department of Justice to slow down or drop cases against Trump. The presidential election in 2028 could potentially bring a Republican administration that would be sympathetic to Trump or that would be willing to grant pardons or clemency. Federal prosecutors understand that the current moment, with Democratic control of the executive branch and with Trump politically weakened by enforcement actions and declining approval ratings, is the optimal time to push cases to conclusion. Waiting creates risks that the political environment shifts in ways that make prosecution more difficult or impossible. The intensification of pressure is therefore strategic rather than reactive. Prosecutors are accelerating timelines and pressing every advantage because they recognize that their authority and leverage may not persist indefinitely. The unraveling of Trump's legal strategy creates significant uncertainty about how the trial will actually proceed. A competent defense team with adequate resources and a cooperative client would focus trial preparation on jury selection, on witness cross-examination strategies, on presenting evidence that creates reasonable doubt, and on crafting a compelling closing argument. Trump's defense team, operating with inadequate funding, internal conflicts, and an uncooperative client, will struggle to execute basic trial functions effectively. Jury selection will be critical because the prosecution's case is strong enough that the only realistic path to acquittal is finding jurors who will engage in nullification based on political sympathy. But identifying such jurors in a Washington, D.C. jury pool requires sophisticated jury consulting and extensive use of peremptory challenges during voir dire. Trump's team cannot afford the jury consultants who would normally assist with this process. The cross-examination of government witnesses will be another critical phase, because creating doubt about witness credibility is one of the few available defense tactics. But effective cross-examination requires extensive preparation, including reviewing all prior statements the witness has made and identifying inconsistencies or biases that can be exploited. Trump's attorneys are not investing adequate time in this preparation because they are distracted by withdrawal motions and funding disputes. The prospect that Trump might attempt to represent himself at some point during the trial, if his attorneys are allowed to withdraw or if they perform inadequately, cannot be entirely dismissed. Trump has a history of believing he knows better than his advisors and of trusting his own instincts over professional advice. According to sources who have discussed the trial with Trump, he has expressed interest in delivering his own closing argument and possibly examining certain witnesses himself. His attorneys have strongly discouraged this idea, explaining that defendants who represent themselves almost always harm their own cases because they lack legal training and because juries view self-representation as evidence of arrogance or desperation. But Trump reportedly believes that his communication skills and his ability to connect with audiences would make him effective in the courtroom. Legal experts who spoke to various media outlets stated that if Trump attempts to represent himself even partially during the trial, the results would likely be catastrophic. Federal criminal trials operate under strict rules of evidence and procedure that require legal expertise to navigate. A pro se defendant, even one with substantial business experience, would struggle to make appropriate objections, to frame questions properly during cross-examination, and to avoid making statements that inadvertently strengthen the prosecution's case. The strategic unraveling extends beyond the immediate trial to Trump's broader legal exposure in other potential cases. The evidence being presented in the election interference trial will be available to other prosecutors who are investigating related conduct. The Georgia investigation into Trump's attempts to pressure state officials to overturn election results in that state has been slower to progress than the federal case. But prosecutors in Fulton County have indicated that they are closely monitoring the federal trial and that evidence presented there will inform their own charging decisions. If Trump is convicted in the federal case, it substantially increases the likelihood that Georgia prosecutors will bring state charges because a federal conviction establishes that juries find the conduct criminal and that defenses based on presidential immunity or good faith reliance are unpersuasive. State charges would not be subject to federal pardon, which means that even if a future Republican president were to pardon Trump for federal crimes, the state charges would remain. The strategic collapse in the federal case, therefore, has cascading implications for Trump's legal exposure in multiple jurisdictions. The psychological impact on Trump of watching his legal strategy disintegrate while facing trial in 18 days is reportedly severe and is manifesting in ways that concern even his remaining loyalists. According to sources who have interacted with Trump this week, he oscillates between rage directed at his attorneys for failing to prevent the enforcement actions in the trial and moments of apparent dissociation where he seems not to fully process the severity of his situation. He continues to insist in private conversations that he will be vindicated, that the jury will see that he was protecting democracy rather than subverting it, and that the American people will rally to his defense once they understand the full story. The sources describe this as delusional thinking that is disconnected from the legal reality of his situation. The evidence against Trump is documented in recordings, emails, and testimony from his own administration officials. The legal defenses have been rejected by courts at every level, including the Supreme Court. The political support has collapsed to levels where even Republican officials are distancing themselves. The business empire is being liquidated through enforcement actions. The objective reality is catastrophic. Trump's apparent inability to fully internalize this reality suggests psychological coping mechanisms that may not be adequate to prepare him for the experience of sitting through a trial where he will hear detailed evidence of his misconduct presented to a jury. The federal pressure will continue to intensify through the trial and beyond because the enforcement machinery is now fully operational and because prosecutors have concluded that this is the moment of maximum vulnerability for Trump. The coordination between criminal prosecution, civil enforcement, regulatory action, and political pressure is creating a comprehensive siege that is designed to force either cooperation, resignation, or complete collapse. Trump has shown no indication that he will cooperate or resign voluntarily. The pressure will therefore continue until collapse becomes inevitable or until some external factor changes the dynamics. The trial that begins on March 10th will be the visible centerpiece of this pressure campaign, the public proceeding where Trump's conduct will be judged by a jury of citizens. But the trial is only one element of a broader enforcement strategy that is executing simultaneously across multiple dimensions. The legal strategy has unraveled, the federal pressure is intensifying, and Trump, surrounded by conflicted attorneys, dwindling resources, and collapsing political support, faces the most consequential 3 weeks of his life with no viable path to the outcome he needs. The unraveling is complete. The strategy that was supposed to create delays and procedural victories has instead created chaos and attorney withdrawals. The funding that was supposed to support vigorous defense has evaporated as assets were frozen and donors defected. The client cooperation that is essential for effective representation has been replaced by interference and contradiction. The federal government, recognizing the weakness, is pressing every advantage and accelerating every timeline. The trial approaches, the defenses are gone, and the outcome, barring unexpected developments, appears increasingly certain.